Hello, we are now in week 9 of the semester. We're going to be doing chapter 8 of your textbook. And this chapter deals with personal representatives, the different kinds of personal representatives, and what they need to do to get appointed and what they have to do before anything can happen in probate court. Okay? Now, there are different kinds, and by the way, what we're talking about is what we've been talking about for these other chapters. A personal representative is someone who stands in your place when you can't be there. So when we're talking about a last will and testament, you're not there. Who did you ask to be your representative in your place? Your executor. And remember, when we do our appointment of an executor, there are a few things. We want to have, first of all, a discussion with whoever it is we think would be best to be our personal representative, be it your spouse, be it your children, a nephew, whomever. You have to have a conversation with them before you get started. And the reason why is it's a pretty big deal being an executor. Being someone's personal representative, according to probate laws, makes you a fiduciary, which holds you to a very high standard. And if you make a mistake, you can be held criminally liable. You can be held financially responsible. So if you invest money for the estate, or you sell something at lower than the market value of whatever it is you sold, you can be held responsible for the difference between market value and what you sold it for. If you transfer property when you're not supposed to, there is criminal liability, there's financial liability that's associated with being a personal representative. It's kind of a big deal. So you always want to have the discussion with whoever it is that you have chosen. Even if it's a bank, even if it's the trust department of a bank, you need to go knock on the door, find out what the fees are, find out what their perspective is, see who the estate and probate lawyers within that trust department, who they are, how long they've been there, what's their philosophy. If it's your bank, then you've been there for, your whole life or for a long time, then you may already know who these people are. These are important things that you have to do before you die, before you name someone in your last will and testament as your executor. So there's prep work that you've got to do. Then once you pass away, the executor has to spring into action. And look, if you didn't know you were going to be an executor, boy, that's a huge surprise, isn't it? And you're not prepared for it. And when you talk to whoever it is that you want to select to be your personal representative, you need to tell them the stuff that's in this chapter. You need to tell them what the expectation is, what their duties are going to entail. And then ask them, is this something you want to do? Because if they don't want to do it, why are you asking them to do it? Okay? So, that's just our precursor to this chapter. Okay? Now, the personal representative has to do a lot of stuff. They have to be aware of time limitations. They also have to go through some hoops to be appointed by the court. Just because you name someone as an executor doesn't mean the court's going to agree that that's a good choice. most states require letters of administration that allow whoever the executor is to do something. Before they do that, they have to be appointed as an executor. There are several steps that have to be taken by the executor once he is appointed. Now, there is a case study in this chapter, and it actually goes through what a paralegal would talk to an executor about. I'm not going to go through this case study, and the reason why I'm not going to go through this case study is it doesn't make a whole lot of sense. It is, at least not for you in Ohio. There's a discussion that is presented in this fact pattern and in this kind of case study where a decedent is represented by counsel with their last will and testament. The executor is the son, and it's a discussion about whether the executor wants to hire the attorney who drafted the last will and testament to assist the executor in going forward with probating the will. So it goes through, what you would do when you read the will with the executor, and that the attorney will then offer to help the executor. Then the attorney basically talks about, what the personal representative must do. That's really the only important part of this whole sample that's in your book. And on page 262, you'll see where the lawyer says to the personal representative the basic duties that the personal representative must perform, which is all of the assets of the decedent must be collected, all of the claims, debts, and taxes that the estate owes must be paid, and the remainder must be distributed according to the will as close as possible. Okay? Then the executor will file a petition to probate the will. And the other kind of only really good part of this example in your text is the tickler form that's on page 263 of this chapter. And a tickler, which my kids think is just the funniest word ever, is a checklist with time limitations. I have a tickler system because my business is that I write legal briefs for other lawyers, or I do legal research for other lawyers, right? And there are deadlines. And if I don't meet the deadlines, then the attorney that I'm doing the work for will lose his law license, because you have to file things up, and that's maybe an overstatement, but it's a big deal to miss deadlines. Okay? So literally, every single morning when I turn on my computer, my digital tickler system says to me, and it literally speaks to me, I feel like I'm on Star Trek, says, "Good morning, Diane. Your tasks for today are," and they'll list them, and then it will say to me, "You have a brief for attorney XYZ due next Tuesday. I see you have not done any work on it since last Wednesday. Would you like to calendar time to work on it? Literally, that's what my computer says to me every morning, because I'm always behind, right? But it will remind me of a deadline and will help me calendar it. The form that's in your book is good for people who don't have Amicus, which is the system that I use, okay? If you don't have a tickler system, if you don't have a system built into your computer, okay, a piece of paper is good. What my brother, who's a probate lawyer, does is he links a client's Google Calendar, or will create a Google Calendar that is a tickler system. And then he has access to it so that he can stay on top of it. Actually, his paralegal stays on top of it. Okay? But the piece of paper is good too. So what are the kind of things that, have to be done? Let's go through them. Original will filed with probate court, petition to probate. Okay? Mailing of notice of hearing. Hearing on the petition for probate or appointment with registrar, affidavit of mailing, bond, letters issued. Okay, so let's take that first bit. Okay? Petition to probate is where you ask the court, you say, hey, so-and-so died, here's the last will and testament. We believe that this is the valid last will and testament, the last one, the one that has not been revoked, created by the testator, by the decedent. Okay? Everybody's got to get a notice of this. Everybody. Who's everybody? Well, remember that intestate succession stuff, right? For people who are related to the decedent. So anybody up, down, sideways in our chart of next of kin gets a notice. Hey, we have this last will and testament that's been filed. We want to probate it. Anybody got a problem with that? Okay. Then there'll be a hearing on probating the will and appointing the executor. Okay? Now, sometimes people say, I don't want this person to be the executor. They filed bankruptcy twice in the last 20 years. I don't think they're a good person to do this. Or, this person lives, 2 states away. I live here in town. It's easier for me to do it. Why don't we let me do it? Okay? The best thing is that everybody signs off, and everybody in the line of succession who needs to get notice signs off and says, we agree, we don't need a hearing, just get on with it. Okay? Usually the attorney that the executor hires will send out a letter to everybody saying, okay, here's a copy of the will, this is the executor, please sign here on this agreed entry, or give us authority to sign on your behalf, or do an electronic signature. We want to move forward with this. Okay? Okay. The next thing, the bond. What's a bond? A bond is an insurance policy, but a bond is a special kind of insurance policy. Okay, right, we think of insurance like when we buy car insurance. Okay, when I get in an accident, they'll pay. Okay? A surety bond is kind of like that. If I'm the executor and I make a mistake and the estate loses money because of it, then the surety bond will pay back that money to the estate. Okay, that's like a regular old car insurance policy, right? Except for now the surety bond is going to look at me, if I'm the executor, and say, okay, you have to pay us back. What? I got to pay you back? That's not like a real insurance policy. Why didn't I just pay it in the first place? Well, because the insurance policy sometimes is best just to make sure that all the money gets paid back quickly in one fell swoop. Okay? That's a surety bond to make sure that the estate is not at risk. Now, in your last will and testament, you can waive a bond, right? And remember, in the law, when we say waive, it's like that song, no, 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 bye, bye. You don't have to do it. Okay? So I can put in my last will and testament that I want Mr. Hetson to be the executor of my estate, but he doesn't have to get a bond. And if nobody objects to that, that's the way it is. The court can always overrule what I want with respect to a surety bond. If the court looks at the executor I've picked and said, not really so sure about this one, I think we are going to require a surety bond. Why would they do that? Well, because the court is there to protect the estate, to make sure that there's no fraud, that there's no malfeasance, that no money disappears. And so surety bond does that. Okay? So the court will, first of all, if the last will and testament does not waive a surety bond, or if the court says you do need a surety bond. By the way, pretty much every state says if you're an executor, you need a surety bond. So statutorily, you got to do it, unless the court in its discretion says no, or unless it's in the last will and testament and has been waived. Okay? So if the court does set a bond, it'll be a percentage of the value of the estate. Well, how do they know? There's going to be some inference drawn from the last will and testament's language itself, and the court may conduct an inquiry into, hey, what are the estimated assets of the estate? Okay, and that actually goes with the petition to probate. There's an estimated value of the estate that goes into that petition. Okay, then the next set of things that the executor has to do comes. Letters issued, notice to creditors, inventory and appraisement. Okay, done. That's the next step, our next big set of steps. Okay, letters issued means the court issues the executor authority to be the executor, to execute the will. Okay, so the personal representative will then go to the bank, open an account, a bank account for the estate, will get an EIN, which is technically an employee or employer identification number. It's for the estate. It's like the social security number for the estate, for the decedent's estate, right? Because whatever's in the estate no longer belongs to the decedent, they're dead. It belongs to the estate, which is its own entity. So it needs a bank account to pay taxes, to pay beneficiaries if they're getting money, to carry out gifts that go to charitable organizations. All of that, you need to have the bank account, and you get an EIN number. Where do you get an EIN number from? Social Security Administration. Okay? So the executor, usually the executor's attorney that they've hired, will contact Social Security, will get an EIN assigned to the estate. You can't open a bank account without a Social Security number, right, as an individual. You can't open a bank account for the estate without an EIN. Okay? So those are the two big things that have to happen. Okay? Notice to creditors and an affidavit of mailing. The attorney will identify who the creditors of the decedent were at the time of his or her death. And will notify them. Hey, decedent's gone. If you have any claims, you better bring them to probate court now or forever hold your peace. Do you see the similarities with the bankruptcy? Because it's kind of the same. Okay? Inventory and appraisement. That means that there has to be a list provided to the court of everything the decedent owned at the time of death. Does it have to be one blue dress, one yellow dress, one white dress? No. Personal property, clothing, shoes, that's enough. Okay? The next step, personal property tax, real estate taxes, and the last date for the spouse's election. Remember, we talked about electing against the last will and testament for your spouse. If you think that you will get more by electing against the will and taking either a third or a half of the estate, then there's a date certain for doing that. Okay? Property is set aside for surviving spouse and minor children. State and other inheritance taxes are due. Last date for creditors to file their claims. There'll be a hearing on those. And then all of the final taxes get paid. You'll see that pretty much a third of what gets done is taxes. Okay? That's why you hire the attorney. Now, the tickler sheet, the Google Calendar, whatever tickler system the probate attorney is using to help the client, the executor, follow along, do what needs to be done, is important. And if you take anything away from this chapter, I want it to be, it is important for the executor to stay on top of things, and for the attorney to stay on top of things also, but also to make sure the executor is on track. That's your job, paralegal. Your job is to make sure everybody's calendars are up to date and nobody's tickler system is falling behind. That's your job. Gather documents, make filings, make sure everybody stays on track. Okay? It just is. Okay? So your book goes through some of the other pre-probate things that the executor needs to do. Obtain certified copies of the death certificate. Usually whoever does the burial or cremation will get several certified copies of the death certificate. If they don't, which again is highly unusual, if they don't, the attorney for the estate will do that. Okay? Set a family conference where everybody sits down and says, hey, this is what happened, this is where we're at, this is what's going to happen going forward. The attorney is usually the one who conducts that family conference. It's also a chance for the attorney to say, hey, are we going to have problems here? Are we going to have someone who contests the will? Are we going to have problems because the will wasn't drafted well? Are we going to have problems? It's a great time to assess where everybody is. Excuse me. It's also a time to figure out if this executor is really going to be workable, if everybody is going to agree to it. Okay? Now your book has different states' petitions to probate the will. Okay, they're all pretty much the same. You can go on the website for whatever county you live in, go to the probate court, and all the forms are there. All of them. So they're really not complicated, and it gives you an opportunity to go forward and at least get an idea of what's going to happen. Okay? Your book talks about the bond. We've talked about that. And again, one of the biggest things that the executor has to do really is gather all the information. The paralegal and the attorney will put it in the right place. But if you can't find, if you're the executor and you can't find documents, if you don't know if there's a mortgage on the house, if you know there's a mortgage but you don't know where it's held, you don't have copies of deeds, you don't have copies of titles to vehicles, It's a mess to be an executor. I'll never forget, I had one client, a son, whose mom was basically a hoarder. And I actually went into the son's house with him. And you could barely get through the door. And there was stuff everywhere. There were stacks of papers, stacks of unopened mail. This woman sadly had been very ill for probably the last 6 months of her life. Didn't do anything. Papers, newspapers. You probably don't even know what a newspaper is anymore. Newspapers, papers, documents. We couldn't find anything. Literally, I went through the house with the son and a dumpster in the backyard. He was the only beneficiary. And we documented everything, threw it in a dumpster. You weren't really supposed to do that. But it was the only way we could find things. We finally found her will. It was in a stack of papers next to the chair that she sat in every night. Just kind of thrown in there. We couldn't find the deed to the house. We couldn't find anything. That's a nightmare for the people you leave behind. So, when you have your kitchen table talk with the executor, or the person that you want to be the executor, you better be very clear with them. Everything will be organized. I will not leave you a mess. Do not leave a mess. Because your personal representative especially will have a nightmare. And usually, unless it's a bank, the personal representative is sad, distraught, upset, dealing with all kinds of emotions, just dealing with your death. Now they've got a mess to clean up on top of everything else. It's no good. All right, your discussion to do, your assignments are in the module. If you have any questions, please feel free to call me.